Ladies and gentlemen, can I just ask, are we ready to start? Are we waiting for anyone else to come into the room on either side? No, no, no. Dr. Weiler is enjoying his breakfast elsewhere. That's not on the record. Yes. It's on the video. Okay. Well, let's then make a start. Before we invite the witness into the witness seat, let me just return to the issues that we closed with yesterday on timing, and ask both parties whether you've had any further thoughts about timing for tomorrow, Friday. As regards the rest of today, we will wait and see how that progresses. The point that I put to you both was whether you thought that the extra half an hour, or effectively 45 minutes of time during your closing submissions would be sufficient for you to be able to address the questions of the tribunal, or whether you thought you needed more time. Mr. Copa?
We won't require more time.
Mr. Alexandrov?
Mr. President, we appreciate the tribunal's willingness to give us that opportunity, and we'll take the time that the tribunal is willing to give us, and we'll do our best. If we don't manage to answer the tribunal's questions, we'll take time out of our closing, because we believe that addressing the tribunal's questions is the most important task of counsel. If there is time today and the tribunal is willing to hear from us today, we'll be ready to take additional time. If not, we'll deal within the time allotted to us tomorrow.
Thank you. As I indicated yesterday, if we have time today, we will certainly be happy to give that over to the parties' responses to the questions. So I think, without more ado, then, I think we have the start of the expert evidence today, and we have Mr. Hedden, I believe. So, Mr. Hedden, I'd invite you to take the witness seat, please. Good morning, Mr. Hedden. My name is Daniel Bethlehem. I'm presiding in these proceedings. To my right, to your left, we have Mark Cantor. To my left, to your right, we have Raul Venuesa. The counsel, those whom you don't know, I'm sure will introduce themselves when they have an opportunity to do so. You have a witness declaration sheet in front of you. I'd be grateful if you could read that into the record, please.
Yes, sir.
Yes,
microphone?
You'll have to press the microphone each time you speak, please.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. Ms. Cohen?
Good morning.
Apologize. Good morning, Mr. Hedden.
Good morning.
You have in front of you a number of binders and documents. If you could look first at the two white binders, and volume 1 of the white binder at the first tab.
May I just ask, do we have the binders?
I apologize. This is his expert report. So I did not intend to hand up new copies of the expert reports.
Yes.
And at tab 1 of the the white binder, I believe is your expert report dated April 23rd, 2014. Is that correct?
Yes, it is.
And does these two binders constitute the entirety of your first report in relation to the matters in issue in this proceeding?
Yes, it does.
Subject to any clarifications that you may make in the course of your direct evidence this morning, does it accurately reflect your opinion on the appraisal of the subject lots in issue in this proceeding?
Yes.
And if I could ask you to look at the surloxed volume in front of you. Oh, I apologize. The paper-clipped copy in front of you, I believe, is your second report in relation to this proceeding. And it is dated October the 1st, 2014. Do you have that?
Yes.
And does this constitute your second report prepared in the course of these proceedings?
Yes, it does.
And again, subject to any clarifications that you may make in the course of your direct evidence this morning, does that accurately reflect your opinion with respect to the subject lots in issue in this proceeding?
Yes.
Now, Mr. Hedden, I understand that you have prepared some slides for the purposes of taking the tribunal through your expert reports this morning. Is that correct?
Yes, it is.
If you'd like to proceed and take the tribunal through those slides, that would be much appreciated. Thank you. We'll just hand them out, so if you could just wait one moment. Thank you, Mr. Hedden.
The first slide on page 2, after the title, goes to my qualifications. I am a recognized and accredited real estate appraiser with over 30 years of relevant real estate appraisal experience. The relevancy goes to the fact that during my entire career, I have spent working in matters involving what we call here expropriation, when in the U.S., in my experience, we've called it eminent domain. So from now on, I'll use expropriation as the appropriate term, and much of my career has been spent in that area. I hold a member of the Appraisal Institute designation, as well as a counselor in the Real Estate Counselors organization of the National Association of Realtors, and I'm a fellow of the Royal Institution of Chartered Surveyors, the leading valuation organization in the world, and I hold the fellow designation, which is the highest designation there. I have a Master's of City and Regional Planning from Rutgers University as well. So given that, I also have prepared my report in conformity with appraisal and with industry standards and all the accepted methodologies of those organizations, here identified as the Appraisal Institute, the Uniform Standards of Professional Appraisal Practice, and the International Valuation Standards, with relevant and appropriate market information to conclude opinions of fair market value. Fair market value is the basis of value that we've used, and again, the market information I deem to be relevant in this matter. In my April 23rd report, I set forth the purpose of the report was to appraise the fair market value of these 26 parcels of land, of certain vacant parcels in Playa Grande and Playa Ventanas, 13 of which are in Playa Ventanas. We have 4 sold takings in Playa Grande, as well as 9 additional partial takings in Playa Grande. The interest appraised in each one of these cases is a fee simple estate, meaning all the bundle of rights that are associated with a fee position in real property. The date of value used in each one of the lots was May 27th of 2008. The lots were physically inspected by me during my visit there on February 11th through 14th of 2014. And it was determined that the highest and best use of the subject properties was for single-family residential development. Given this report, I have certain extraordinary assumptions, and to that extent, the properties were subject to a partial taking, and the government surveys provided did not extend the full 75 meters. We'll talk about that a little later, but in fact, we're short of the 75 from the 50-meter high water line, the public property. With respect to the SPG lots, the expropriation takes approximately 66 meters of depth. With regards to the Berkowitz, we refer to the Berkowitz as the B lots. The expropriation takes approximately 71 to 73 meters, and that's what the survey showed, or the plano. However, we know that the 75 meters was then to be expropriated, and therefore my calculations later here will show the values to the extent of the 75-meter expropriation. Therefore, the summary of values provided both conclusions on the assumption that the part taken is consistent with the government surveys and on the basis that the amount taken is actually intended to extend to 75 meters. In assessing the fair market value, appraisal standards for an expropriation requires that the scheme, which we call the scheme or project, the influence of the project or scheme, its imminence, and everything flowing from the scheme must be ignored in ascertaining the highest and best use before the taking and in the estimate of value. Therefore, Based on my personal interviews, extensive, market data research, and inspections, I selected comparables that appeared to be reflective of market value rather than those that appeared to be affected by intended expropriation. The valuation methodology was a sales comparison approach, which is the most appropriate when you're valuing vacant parcels of land. The development valuation model, which is used in the SPG 1, 2, and 3 lots, was used only to support the sales comparison approach. That's used for properties that has development potential in a larger scale other than a single family, other than a single lot. For lots partially taken, the proper methodology requires an analysis of the parcel before and after the taking, with an analysis of severance damages as appropriate for the remaining parcel. And in that regard, the severance damage reflects the portion taken and the value of that is allocated over the remaining piece, and that's what we talk about with regards to severance damage. So the proper valuation methodology for an expropriatory taking requires the valuer to ignore the impact of the expropriation scheme on the value of the property. The comparables that were influenced by the expropriation scheme were not selected. Comparables within the park that were used by me in this valuation are generally reflective of land values
Mr. Hedden, may I just stop
outside the park.
May I just stop you for a moment? I think that you may be speaking a little bit too quickly for the interpreters, please.
Sure, I'll slow down.
Thank you.
The federal rule. So part of your analysis in doing expropriation follows a federal rule, what we've adopted as a federal rule in our nomenclature in the appraisal standards. That means that the damages are calculated by valuing the property before the taking, less the value of the remainder property after the taking. And this is the key point. It is the property owner's right to receive the market value of the land taken, and the before and after taking valuation methodology will account for the contributing value of the part taken. It's about the contributing value of the part taken, which is my primary focus here. We also, in the valuation methodology, which is part of the standard protocol and theses that have been written regarding this topic, is a theory known as the larger parcel theory. Now, that's a parcel taken through condemnation and expropriation is not a complete parcel, right? So the part taken is not a complete parcel. It's part of a larger parcel where the owner is entitled to damages from the severance as well as the value of the parcel taken. The parcel takings that cannot be directly valued must have their value estimated as a function of the value of the larger parcel. So in the Berkowitz case and in the SPG case, those parcels cannot individually be valued and have to be part of the larger parcel because they are separated and don't subdivide easily. So here I'd like to take you through an example of my valuation methodology or the valuation of a Playa Grande lot, a lot C96.
And Mr. Hedden, just before you move into that, would it assist to have page 61 of your first report in front of the tribunal?
Yes, it may. Page 61 of my report, if you could refer to my report, or if you actually look on page 10, you'll see a summary of the chart that I'm going to describe. So you can look at the report, or you may flip ahead a little bit as I talk through slide number 9. The data for each one of these 3 comparables is set out in my report.
I'm sorry, Mr. Hedden. I'm looking at your first report. You said on page 10.
I think I said page 61.
I think he meant page 10 of the slides.
Page 10 of the slides and page
sir.
61 of the. Okay, thank you.
Yes, sir.
Thank you.
So the data for each one of these 3 sales is set forth later in the report that is not necessary to look at now, but it's in the back of the report, pages 83 to 85. Now, there's a wide disparity in the unadjusted and adjusted sale prices for what would appear to be similar properties. And this was a problem or a challenge, I should say, in valuing these properties, that there was a wide variety or dissimilarity in terms of some of the pricing. And that's attributable to a lack of an efficient and transparent marketplace, which I believe was adequately discussed in my report. The market condition adjustment is related solely to the monthly appreciation determined to be a market-based conditions as analyzed. So we've analyzed all of these based upon the inflation or the market appreciation that was going on for these lots during the time in question.
And Mr. Hedden, sorry to interrupt you, but just looking at page 61 of your report, the market conditions adjustment that you're referring to are in the middle of the box on the second half of the page. Is that correct?
Yes.
Thank you. Please continue. And perhaps continue in reference to just pointing out where in this portion of page 61 you're referring. Thank you.
So you can see on page 61 in the middle of the adjustment process in the lower portion of the page, the line item that goes to market conditions. And you can see then that there's an adjustment of, say, 10% to sale number 1, an upward adjustment of 8% to sale number 2, and an upward adjustment of 45% to sale number 3. And those are based upon the market condition adjustments that you see and discussed on page 24 of my report, meaning that there was a 2% adjustment for a period of time, and then it moved to a 3% per month adjustment, and then slowed down to a 1% per month adjustment during 2007. There's no appreciation was viewed during the 2008 timeframe. So no adjustment was necessary for the influence of the expropriation scheme, as the comparables used did not consider the scheme. So on page 10 of my presentation that I have here today, you will see then that summary and explaining the adjustment process, because these appraisals were done on all of these parcels with a computer model. And there were certain rules that were built into the model that allowed me then to develop the valuations throughout these 26 parcels uniformly, and some reference of homogeneity, if you will, between parcels. And that's why some of the numbers appear consistent throughout. And the model and the rules of the model are shown on slide 11, which we'll talk about momentarily. But let me walk you through slide 10 now so that you understand how the process worked. As counsel had alluded to, this is similar to page 61 in my report. However, you'll see now on page 10 in the presentation here today, there are additional line items with some numbers in the middle of the page. So the narrative that was shown on page 61 is now amplified with the adjustments that you see here. And the rules said that in Playa Ventanas, which was 6% superior to then this land in Playa Grande, was applied uniformly across, so there was a negative 6%. It was superior, and so that the adjustments work contrary to the narrative definition, you adjust from that property to the subject, and Playa Ventanas is viewed as superior to Playa Grande. And then there's a size formula, and so to the extent now that these parcels are all smaller, there's an economy of scale, and it's cheaper by the dozen. So larger parcels usually sell for smaller than big parcels. So all of these smaller parcels then had a higher unit value, and therefore it was adjusted downward, right? So that the smaller parcels had a higher unit value. It also then adjusted downward by 6%. So that it's a negative 12%, and 0% adjustment, right? Because that last line for the physical is similar, so it got 0 adjustment. So that overall, you then had a negative 12%, which then takes you to the next line down, which is adjusted sales price per meter squared, which was $681 for sale number 1, $548 for sale number 2, $994 for sale number 3. Now, part of this process is to correlate or put weight on the various comparables that you believe have the most influence in the valuation of your property. And in this case, there was a 40% weight ascribed to sale number 1, 40% sale 2, and 20% to sale number 3. And when you apply those various weights to those unit indicators, the ultimate conclusion here for this value was $690 per square meter, resulting in a value of the lot of $1,343,386. And then that was rounded to $1,343,000 in US dollars. Now, underlying this model, we can flip to then slide 11 to look at all of the nuances to our model. And this is the rules that the entire model followed throughout the valuation. So these rules were established through my analysis of all the market data that was in the market adjustments. And in data, in analyzing all of the sales information, we abstracted adjustments, and they were used as the basis for these adjustments in the model. And so Playa Flamingo was determined to be 25% superior to Playa Grande. Playa Ventanas was determined to be 6% superior to Playa Grande. A 66% upward adjustment if the lot is beachfront compared to an interior lot. Under size, under the economies of scale that we've discussed, when the difference was less than 10,000 meters, there was a 60% adjustment. So if the sale was, again, 1,000 meters and the comparable sale was 14,000 square meters, then there would be a 60% adjustment. So it was the differential between the two sizes that resulted in an adjustment. So when the difference was less than 10,000 meters but greater than 5,000 meters, there was a 25% adjustment. When the difference was between 5,000 square meters and 500 square meters, there was a 6% adjustment. And if the difference between the two comparables was less than 500 meters, there was no adjustment at all from the size criteria. And then in physical, the descriptions are as such that when you had interior topography of the Playa Flamingo lot, it was adjusted downward 10%. The topography there was inferior to the subject properties because all our properties were level. The undersized B lots adjusted downward by 65% and or 25%. We'll talk about the undersized nature of the remainder of the B lots later in my discussion. And so that they were adjusted down because they were not conforming to zoning. And then the B entitled lots are considered 5% superior to unentitled remnants. So when we had in this case, certain lots that were entitled, which we'll talk about a little later, versus comparison to land that was not entitled, then there was a 5% superior adjustment made. And the before B lots have inferior frontage, all right? So the B lots had an inferior frontage ratio to the lot V61 when that was compared, and that required a downward 25% adjustment. Therefore, the V61 was superior because it had much more beach frontage or beachfront frontage as compared to the B lots. So those were the rules that were underlying this entire model. So as those properties, as the subject properties were laid into the model, those adjustments were mechanically made, and these are the results that we found. Again, focusing on the portion taking and the balance of the ultimate value of the lots relative to the balance that we found for the compensation for the parts that were taken. So here, in weighting the estimated value conclusion, I used professional adjustment to assess and analyze the relative similarities of these properties, and they varied from certain properties based upon the weight that I was giving to the various comparables, whether it was more proximate to the sale, whether it had greater or less adjustments, and that was part of the weighting process that I put into the model. And the disparity between the resulting adjusted prices of the comparable transactions after market-based adjustment is symptomatic of a lack of an active, efficient, and transparent marketplace. Again, lack of multiple listing, for instance, would be one where you don't have as much information available, and you would expect in those markets that you have greater disparity between the prices because of that factor. It's just not as efficient as we have here in the U.S. So in the valuation of Lot 39 and Lot 40, in doing my work before I come here today, I realized that there was a problem looking at those comparables to the extent that if you look at page 58 and 59, you'll see that in the report, we're referring to the report now, where my adjustment for Playa Grande Lot A39 and A40 in the comparable number 2 was identified as an interior lot, but yet there was no adjustment made for that. Clearly inferior to the subject property, which was beachfront. And notwithstanding the time spent, it was in my preparation here today that identified that error, and I have corrected it here in my slides, and we're discussing it here on slide 13, and then on 14 and 15, there'll be an adjustment here for, thank you, for that interior lot in sale 2, which is now 66% inferior to the Playa Grande A39, which is in fact a beachfront lot. So an upward adjustment of 66% is made. And in the same in lot 15, slide 15, where we have an identified lot A40, and again adjusted the oversight by upwards of 66% to sale number 2. The variance between those two transactions is identified on slide 13, which in sale 40, in lot A40, it went from $537,000 to $570,000 for lot A39. And for lot 40, the value was revised from $532,000 to $564,000, a relatively small valuation change overall in the scheme of things. And the unit value went from $596 per meter in the A39 to $632 per meter. So again, not a significant but meaningful difference when you realize that I erred in not valuing for the interior lot in sale number 2 as relates to a beachfront lot
Mr.
in
Hedman,
A39 and 40.
may I just, for the formality of it, just make sure that we understand for the record that you've just said to us now that your slides at page 14 and 15 are intended to be a substitute, a correction for the slides at page 58 and 59 of your first report. Is that correct?
Yes, it is, sir.
Thank you very much.
Moving on to the SPG situation. I have identified on slide 16 the beginning of the understanding of how the larger parcel theory and how this severance damage results. And so that is from the federal rule as well as the larger parcel theory are exemplified then in slide 16. And it'll help you understand as we have these partially taken lots how this theory works. You have the valuation of lot SPG 1 as an individual parcel now. All right, we're going to talk a little bit before when we talk about the unity of use and the unity of title as a highest and best use when all of these properties are assembled. But here we're talking about just individual SPG 1. And the valuation based upon the comparables shown in my report is for the, again, this is based on the assumed correct land area to the 75 meters. We've assumed now that the 75 meters is controlling, and this is the larger lot of 16,801.73 square meters. And we've developed from our comparable analysis a unit value of $207 per square meter. That results in a value, as you see here, $3.478 million. Now, the value of the 3,000 meters that were taken has to be part of the larger parcel. The value that's ascribed to the part taken is the value of the larger parcel because that's what it is. It's part of a larger parcel. However, when you look at the value then of the remaining under that same $207 a meter, you see that it's $2.857 and $66, $2,857,066. Now, the contributing value of the remainder is then that of the remaining parcel having lost the most valuable component to the front, all right? And the value of that is then allocated over the remaining parcel. And you can see as a result here that the total value of the taking is $2,046,000 when you add the severance damage back to the part taken, so that the compensation then, or the value of the part taken, shall we say, is $682 per square meter. So the indicated value per meter is the part taken is comparable with the unit values of the parcels that have been taken in their entirety. Consistent with our valuation methodology, this is the amount that the property owner would have received for the part taken had it been sold on the open market on the valuation date. And that's the theory that goes in here. It's just an allocation. This idea of severance value is nothing more than an allocation of the value of the part taken that's spread out over the larger parcel. So that's what's consistent with the federal rule and the larger parcel theory, and why one considers then the highest and best use and other issues that I've talked about, and how this theory works. And this is all a peer-reviewed theory, and as part of the Appraisal Institute that I've been teaching not only to other appraisers, but also to other lawyers as part of continuing education in eminent domain seminars or expropriation seminars. So moving on then, in slide 17, we see that the before value has been enhanced by the unified ownership of the larger parcel. So here we go to then a larger parcel, because SPG 1, 2, and 3 are all owned by one individual. They can also be unity of use, unity of title, and then physical contiguity. And those are the three things that you look at when you're looking at highest and best use in these contexts of part of a larger parcel. And in this case, the Spence and Company had prepared a subdivision plot for 44 residential lots. So collectively, you have 87,317.26 square meters with over 200 meters of beach frontage. And then the property is level and generally open. Frontage offers a view of the ocean. And then the taking removes 8 oceanfront lots. And we'll have a map showing it momentarily from the subdivision layout. But here's the calculation, and you can see that there's 17% of this parcel is taken. 15,000.75 square meters is ultimately taken, which constituted the 8 front lots. The map now you see on the next slide, on 18, then indicates the nature of the taking. And you have the inalienable zone of the first 50 meters, then there's the 75-meter strip behind, and then the interior lots behind that. The remainder of the subdivision, it's 125 meters more removed from the water line. The remainder is damaged by not having the associated prime ocean front land associated with it. The access and view of the beach, ocean, and sunsets will be lost by the 75-meter setback of the beachfront lots, and the buffer vegetation inside that beachfront will grow undisturbed. The pro rata share of value of the ocean, and this is the key point, the pro rata share of the value of the oceanfront land far outweighs the value of the land now 125 meters back from the water line. Therefore, the remainder value has a lesser unit value, dollar per square meter, than the unit value before, and the remainder suffers a severance damage as a result of the taking. So when you take this green area here, which is the most valuable portion, that, as you can see from that prior slide, was reflective of about $682 per square meter. And then that loss of that portion, that higher void, is spread out over the remaining lands. Next slide, please. So the severance thing is just an allocation of the loss of value over the remaining lands. And again, we've proven through our comparable analysis that the 104 meters in the after was the appropriate number. Remainder does not become, in here, the SPG, right, the remainder does not become beachfront. Lots closer to the beach will sell at a premium to lots that are further from the beach. This is a simple economic concept that just says if you're closer to an amenity as compared to farther back, there's obviously more value in that land that's closer to the amenity. Loss of beach access also results in a decrease in value of the remainder. Assuming the correct land area is taken, 15,000.75 square meters, the resulting total taking value is a very reasonable, again, $8,472,000, or $564.77 per square meter. So as you can see from even looking at the Ventanas lots where we were at $805 per square meter, here we're on 15,000 square meters and 8 beachfront lots. We're only talking about $564 per square meter. Next slide, please. So it takes us to the B lots and how we look at the B lots now in B1, 3, 5, 6, 7, and 8. The taking places the property, like in SPG, 125 meters away from the water line and removes the subject property's fee simple title land most proximate to the oceanfront location. The pro rata share, I'll slow it down a little bit because I probably, okay. But I'm trying to walk through this in a time frame. The pro rata share of value of the oceanfront land far outweighs the value of the land now 125 meters back from the water line without access. Therefore, the remainder value has a lesser per unit value, dollars per meter, than the unit value before, and the remainder suffers a severance damage as a result, very similar to what we just talked about, all right? Same economic concepts. The severance damages are more severe for these lots, and there's a higher adjustment for that. And why? Because the remainder properties are now undersized and they're remnant parcels. There's less than 5,000 square meters for the remaining portions that cannot be independently developed. In the SPG lots, you had land that could be independently developed. You still had a subdivision that could be created. Here, where you have undersized building lots that are not don't have unity in use, they're all used, but unity in title, except for B5 and 6, they can be combined, and we'll talk about that. The lots 5 and 6 are under common ownership and can be merged, and therefore the damage to these remainders is less severe. So you have higher damage in 1 and 3 and 7 and 8 because those are uneconomic remnants that are left behind, so that there's more damage to that front that's allocated to the loss of the front. But 5 and 6 can be merged because Mr. Berkowitz still owns them commonly, and they could be merged together. So they are still damaged somewhat, but not as severely as the others. So in these B lots we talk about here, you can see the magnitude of the take. The properties are level and generally open and offer access and views of the ocean. The size of the individual parcels before and after, and the parts taken is shown in the chart below. After the correct land area is taken, all right, so that's 18,274.5 square meters, the resulting total take is $14,176,000, or $775 per square meter, still within reason for oceanfront property, yet indicative of the greater severance damage suffered by these lots. And you can see in the after condition that none of them are at the 5,000 square meter as required by zoning, and you can see that they're on average, say, 40% taken. So in summary then, on pages 22 through 24, you'll see here, and what I want you to focus on is the total value of the taking and the value expropriated per square meter. And you can see that there is a reasonable balance between the actual taking of the total take and the severance damage when you look at the expropriated value per square meter. Again, we're focused and reflecting on the portion of the property that was taken and what its values are. And notwithstanding the way we've arrived at it using the larger parcel and or the federal rule, you can see that overall there is balance and consistency in the analysis. And so in summary, on page 24, you'll see that when you add up all the values of the parts taken for these 26 lots, you end up with $36,608,000, or $710 per square meter for all of the lands. Again, given the analysis that we've shown, even in the Ventanas at lots at $805 per square meter, you can see that at $710. And not only that, it's not only the land that we've appraised and shown in my document, but of all of the data, it's also contained in all the exhibits from the interviews and all the other market data I've analyzed. I believe that that isn't true, the true value of the part taken.
Thank you, Mr. Hedden. If you could answer any questions that the respondent may have for you.
Say with McCandless.
Yes, thank you, Mr. President. Mr. Hedden, we're going to pass around a binder for the cross-examination purposes, and I'll wait a minute until we get that binder passed out. Good morning, Mr. Hedden. My name is Jennifer Haworth McCandless, and I'm representing the respondent in this case, and I'll ask you a few questions related to your report.
Thank you.
And behind tab 1 is your first report, and in section 2.3,
Can you give us a page?
it's on page 9. Section 2.3, which is towards the bottom of the page, you have identified the date of value that you are using to calculate damages May 27th, 2008, correct?
Yes.
And you state that that date, the basis for that date is the Chamber of the Supreme Court decision of 2008, correct?
Yes.
And this is a decision in which the Constitutional Chamber of the Supreme Court ordered Menai to expropriate land or asked them to do it quickly within the park, is that correct?
That's my understanding.
And you selected that date because that was the date that claimant's property was expropriated, or that you were informed that that was the date that they were expropriated?
That was the date that I was instructed to value the properties on.
Were you told the reason why you were instructed to use that date?
No, counsel informed me that that was the date that we were to, that I was to value this property, and it coincided with the date of the Supreme Court decision, as you've said.
Thank you. And if you look at the page preceding that, in page 8 of your report, which is under 1.6, section 1.6, and you're talking about extraordinary assumptions. And you say in the highlighted text, or the bolded text there, that it is your understanding that the expropriation in this matter was to include 75 meters inland from the mean high tide water line. Is that correct?
Yes.
Is that, do you know if that's consistent with the park law from 1995 as to what the 75 meters constitutes? That's part of the park?
That was my understanding.
So that would mean that if the 75 meters are from the high tide line, it would just be 75 meters inland from the high tide line as opposed to further inland from that?
No, it was 75 meters from the 50-meter inalienable zone from the Millones.
Okay, so this is a typo the way you've described it here, because I think you have it 75 meters inland from the mean high tide water line, and you're not mentioning the 50 meters there, are you?
That is correct. You have identified a problem with the language there, and it was 75 meters from the, after the inalienable zone, right. So it was back from the Millones.
Okay, so you're not assuming that the property is further, I mean, that you weren't evaluating then property that was right up next to the high tide line. You were evaluating the property that was back 50 meters from that. Is that correct?
Yes.
Okay, thank you. In the sentence that follows that one, in that same paragraph, you say, however, for those properties that are subject to partial taking, the government surveys provided did not extend 75 meters from the mean high tide water line. Is that correct?
Yes.
And did you mean that in some instances, Costa Rica did not actually expropriate the entire 75 meters that were subject to being expropriated?
What it means is when I looked at the planos for those parcels based on the government surveys, they did not extend back 75 meters from the Millones. There was only, again, my paperwork said 68 feet or 71 feet, so, excuse me, meters. It was only going back 66 or 68 meters and didn't go back the full 75 meters from the 50-meter inalienable zone. And that's what I meant here.
Okay, and in the sentence that follows, you said FTI adjusted the areas to be included in the parts taken and calculated alternative values based on the adjusted area. And by that, you mean that you, notwithstanding the fact that the government was taking less than the 75 meters, you calculated a value assuming that the full 75 meters were taken. Is that correct?
It was unclear to me as to whether the planos, which did not show the full 75 meters, was in fact correct. And given the indication that there was going to be an expropriation of 75 meters, I then adjusted it to mean the 75 meters versus what was shown in the planos. So there was uncertainty, and we adopted the 75 meters as the appropriate benchmark for valuation.
Okay, as opposed to going the other direction and being a little bit more conservative and taking the amount that you actually saw that was indicated.
I just went by the letter of the agreement that it was to be 75 meters, and I thought that was more appropriate.
In section 2 of your report, which will go to page 9, which you have indicated in that first paragraph that you are to provide your expert opinion regarding the value of vacant lands taken from the claimants as part of an expropriation from the respondent. Is that correct?
Yes.
So you are not calculating damages for a breach of fair and equitable treatment provision or for any other provision in CAFTA, is that correct?
I was only focused on the market value of the parts taken from the property.
But in the context with respect to expropriation, correct?
Yes.
If you could turn to section 3.1 of your first report, which is on page 10. And you state in that first paragraph that market value is, quote, the estimated amount for which a property should exchange on the date of valuation between a willing buyer and a willing seller in an arm's length transaction after proper marketing wherein the parties had each acted knowledgeably, prudently, and without compulsion. Is that correct?
Yes.
So you would agree, would you not, that the market value takes into consideration the knowledge the parties had at the moment of sale regarding the property that's being sold?
No, the definition of market value assumes a hypothetical willing buyer and willing seller both acting prudently and with fair knowledge. So the market value of the properties that I've assumed, that I have valued, assumes a knowledgeable buyer and seller.
Correct. So it's the knowledge that the buyer and seller have that is taken into consideration when determining the value of the property, correct?
It's assumed in the estimation of market value in valuing the properties. That's correct.
Yes, that's what we're talking about. Were you present during the hearing? I'm not sure if I noticed if you were here or not. Obviously, you could have attended, but I wasn't sure you were here.
Specifically, no, I was not here. I just arrived yesterday, last night.
Okay, and did you listen to testimony in advance of your arrival?
Yes.
Okay, so were you aware the testimony of one of the property owners in this case, that of Mr. Brett Berkowitz?
I was aware that he testified.
Okay. And Mr. Berkowitz has property, he purchased property in the B lots, as you mentioned earlier in your direct, B1, B3, B5, B6, B7, and B8. Is that correct?
Yes.
So I don't know if you recall, but Mr. Berkowitz had stated in response to a question from cross-examination, and I will point you to that in the binder in front of you. It's behind tab 9. And it's page 407, if you could turn to page 407 of the transcript. Do you have that?
No, behind tab 9 only goes from page 396 to 399.
You just need to turn the page. Sorry, there's a blue sheet in between.
Oh.
Sorry, I should have explained that. So if you turn after the blue sheet, then you'll have, I think, 407. Do you have that?
Yes, I do see it.
Okay. And in lines 16, beginning with line 16, Mr. Berkowitz was answering a question, or here's the question to Mr. Berkowitz in cross-examination. Is it correct, Mr. Berkowitz, that the document reflecting that transaction, and that was a sale for the purchase of the lot, the B lots, among others that we just discussed, provided that you, as the purchaser, would not have a claim against the seller in case the properties were expropriated in the future? Answer, that is correct. Do you see that?
Yes.
So Mr. Berkowitz, when he purchased the B lots, he's admitting in his testimony that the property that he was purchasing was subject to being expropriated. Isn't that correct?
I object to the question.
You want to elaborate on your objection?
The basis of the objection is that it's not appropriate to put testimony of another witness to this witness and ask him to interpret it.
It is relevant to what information Mr. Berkowitz had at the time that he is purchasing the lots, and we just established that knowledge of the purchaser is important in determining the valuation, and that goes to assumptions, certain assumptions that were made by Mr. Hedden in his damages evaluation.
I don't think that you can ask the present witness anything relating to Mr. Berkowitz's state of mind. I think you can ask the present witness in relation to information that he considered for purposes of his valuation.
Okay. So Mr. Berkowitz is indicating here that he has that the property was subject to being expropriated, and that was included in the sales contract. Isn't that the exact type of information that is necessary to consider when determining the fair market value of property?
No.
Doesn't it go to the knowledge of the purchaser with respect to the purchasing of the land? And isn't that something that we just established was part of the determination of what the willing buyer and willing seller have in their minds when they're purchasing the land that affects the value of the land?
I think the statement would indicate Mr. Berkowitz's knowledge. However, that is not reflected in market value. The definition of market value here in this case does not refer to Mr. Berkowitz's knowledge at that time.
We just discussed, and we'll go back to page 10 of your report in 3.1, and the definition of market value that we discussed is, and I'm quoting from your report, market value is the estimated amount for which a property should exchange on the date of valuation between a willing buyer and a willing seller in an arm's length transaction after proper marketing wherein the parties each had acted knowledgeably, prudently, and without compulsion. So knowledge is a component of determining the knowledge of the buyer and the seller are a component of the value of that property. Isn't that correct?
Yes.
Okay.
However, you're alluding to that price is equal to market value, and that's not true.
What I'm asking you is, do you have to take into consideration, or is it part of the determination as to what the market value is, the knowledge of the willing buyer and the willing seller at the time of the transaction?
Yes, and as I testified, the definition of market value assumes under a hypothetical transaction between a willing buyer and willing seller, knowledge. And that's the key word there was hypothetical. Price that we're talking about here is not reflective of market value, and it was not considered.
Right, but knowledge is important to take into consideration. The knowledge of the willing buyer and willing seller at the time is important to take into consideration when determining the market value of property, correct?
Yes.
In collecting information regarding the Costa Rican real estate market in 2008, you state in page 19 of your first report, that you relied on conversations with brokers in Costa Rica. Is that correct?
Yes.
One such broker was Miss Penelope Lent. Is that correct?
Yes.
And Miss Lent is a realtor in the Guanacaste area. Is that correct?
Yes.
And if we turn to your second report, which is behind tab 2 of the binder in front of you, in section 2.1, page 11,
Yes.
at the end of the second paragraph, you say that during my interview with Miss Penelope, it's the last line there, during my interview with Penelope, she said that she continued to sell in this area, as did others, despite her concerns, and she was confirmed that the values ranging from $500 per square meter to $1,000 per square meter during this time. Is that correct?
Yes.
And you have attached to your report a letter from Miss Lent. Is that correct?
Yes.
And let's take a look at that letter, which is behind tab 3 in the binder in front of you.
I'm there.
Okay. And if you look at the middle of that letter, it states, does it not, that in 1, 2, 3, 4, fifth line down?
Yes.
It says from 2005 to 2008, beachfront land property values ranges anywhere from $500 per square meter to over $1,000 per square meter, depending on the market, location, and specific characteristics of a lot. However, during this time, between 2005 and 2008, I only sold one beachfront lot in the Playa Grande area due to concerns over the legal and expropriation risks upon the creation of the national park. Is that correct?
Yes.
So although she did continue to sell land during this time, as you were suggesting in your report, in fact, she only sold one lot in the period of 3 years. Is that correct?
No.
Isn't she saying here that she sold only one beachfront lot in the Playa Grande area?
That's what she said here.
Okay. And she says here also that the reason she did not sell more was because of concerns over the legal and expropriation risks due to the creation of the national park. Is that correct?
That's why she didn't sell any more lots that were inside the park in Playa Grande. That is correct.
So the fact that certain land in that area was considered part of the park had an impact on the ability to sell that land. Is that correct?
Had an impact on the ability to sell land that was subject to expropriation. That is correct.
Yes. Okay. Thank you. And if you turn to your first report in page 58 and 59, where you were discussing earlier today in your direct. And you were pointing us to a correction that you were making with respect to the sale of lot C71, correct?
Yes.
And lot C71 was property that was sold by Spence Co. To a buyer. And is it correct that that was sold in 2007?
Yes.
And is it correct that that contract, that sale, was conditional and actually came back to Spence Co. because they were unable to get the building permits that they were saying was a condition of the sale?
I am unfamiliar with the condition. I do know that the land reverted back to Spence Co., but the exact reason for its reversion is not clear to me.
Okay, if it were because of an inability to get a building permit because the land is in the park, would that mean that that fact has an effect on the sellability of that land?
The inability to obtain a building permit clearly would affect the saleability of that land.
Thank you. In your damages calculations, you are not taking into consideration the account of claimant's actual knowledge or the fact that the property is located inside the Los Balas National Park, are you?
Under appropriate valuation methodology, one is to ignore the impact of the scheme prior to the date of value. So that is correct.
That may be true under most circumstances where the property is unaffected until it actually, that scheme, as you're calling it, comes into play. But as here, as we're talking and we're establishing through various points that we've just discussed, the property that is already in the park prior to this, prior to the purchase, then that information of the buyer, that knowledge, as we've discussed earlier, is relevant for the purposes of valuing that property, is it not?
In the cases of properties that I've used, the knowledge did not impact the price paid for the parcel, and therefore it was not considered.
You, though, in your valuation expressly state, and we could turn to page 18 of your first report, and in the second full paragraph, first line on page 18, you say, and I quote, "In valuing the property before the taking, the influence of the scheme is ignored," close quote. Is that correct?
Yes.
But ignoring information that a buyer knows when he's purchasing the land is inconsistent with your own definition of market value, isn't that right?
Could you repeat that question?
Sure. Ignoring information that a buyer knows when he is purchasing the land is inconsistent with your own definition of market value. Isn't that correct?
No. And the reason why is that two reasons. Under the definition of market value, you have a hypothetical willing buyer and willing seller with acting in full knowledge. In this case, any impact of the scheme was to be ignored, as we've called out, because that's consistent with standard appraisal protocol in valuation for eminent domain, and in this case, expropriation, to then ignore any impact of the scheme, and that's why we have called it out specifically for that purpose.
I understand that, and I understand that a normal
Sorry,
circumstance...
the witness said he had two reasons, and he was not allowed
Sorry.
to give the second.
Please go ahead.
And in regards to estimating market value in this case, we were careful to select only those comparables where the knowledge did not impact the price that was paid for the sites or for the lots. So we have, as you stated, that is correct from my report. However, that was not included in the valuation analysis because the comparables were sure to include only those sales where the knowledge didn't impact the value paid.
Yes. So with respect to your first point, that assumption that you're making is valid, or might be valid, in circumstances in which the knowledge of the scheme, if you will, happens after the transaction date, once you've already purchased the land, and that affects the value of the land. But this situation is different, as we've just discussed, with respect in particular Mr. Berkowitz and his knowledge at the time of purchasing the land. And in this case, in these situations in which the buyer has knowledge about the scheme and nevertheless purchases in light of that knowledge, that if we're looking at the full knowledge that a buyer has in the transaction, then it is inconsistent with your definition of market value to ignore that information that that willing buyer has at the time of purchase. Would
I
you agree?
apologize, but I object to the question. It appears that Ms. McCandless is making submissions to the witness that are not questions.
I think that there is a question there.
There was a question there, yes.
Ms. McCandless can put that as a question. I think this is a point that she can pursue.
So my question was, with respect to the definition of market value that you have in your report, in which we've discussed, where the market value is the data valuation is information that the willing buyer and willing seller have at the moment of that transaction, the knowledge that they have, the fact that the buyer has knowledge of the scheme and nevertheless purchased the property, that information that the buyer has, the fact that he has that, if you ignore that, aren't you being inconsistent with your definition of market value, which you
No.
have in your report,
No.
for the reasons that you had given before?
Yes.
On page 24 of your first report, which is behind tab 1, we'll turn to page 24. In the paragraph under the heading Market Conditions, you state that the overall monthly appreciation for real estate in the Playa Ventanas and Playa Grande region was approximately 3.5%. Is that correct?
Yes.
And for the purposes of determining fair market value of claimant's properties, you applied that monthly market trend until the date of valuation. Is that correct?
I applied a monthly trend based on the information shown on page 24 to the comparable transactions that we identified in estimating market value.
Okay, thank you. And if you turn to page 19 of your report, and you, in the second full paragraph, the last sentence, you state that the inflationary trends that were evident in the market in 2003 continued until early 2007, when the real estate recession commenced worldwide, correct?
Yes.
So therefore, there was a, by your own description, an effect or a drop on the market price in 2007, correct?
No.
There was no drop in market price after when you entered in, when real estate entered into a recession? Is that what you're testifying?
I'm testifying that the market trends that we identified from the actual information provided to us is shown on page 24 of my report.
I understand, but I'm talking about specific points in time, and what we were just discussing before was a trend, right? So the trend of 3.5% increase in value. Here, I'm talking specifically about the market in the Guanacaste area, and you are saying that the market in 2003 continued until early 2007, when the real estate recession commenced worldwide, and that affected, did it not, the property sales and transactions in the Guanacaste region?
No, it did not.
So your testimony is notwithstanding the fact that there was a real estate recession worldwide in 2007, that property values in the Guanacaste region continued to increase at a rate of 3.5%?
No.
Okay.
You're linking the worldwide recession to the properties in Guanacaste. And we have identified, as you've shown, on page 19, that there was a worldwide recession. We all understand that. However, what's overriding to all of that was the information provided by the brokers relative to the price appreciation and what they saw in the local market, coupled with the analysis that we've shown on 24, and then our ultimate conclusion as to my monthly inflation factors, which shows no appreciation during 2008. Clearly, the market's slowing during 2007, and we have stabilized and used a trend line, a straight line trend line, in understanding, or not so much straight line because it moves. It goes from a 2% to 3% back down to 1, and then flat lines. So we do recognize that the market has slowed down, and that is what I'm testifying to today.
All right, so you're saying that you have indicated in, sorry to jump around, but page 24, the overall monthly appreciation from April 2004 to March 2007 was approximately 3.5%, but you're not talking about what is happening thereafter here, are you? You're not indicating that that is also increasing at that same rate?
No, what you can see is when you look at Playa Ventanas lot V52, and that sentence specifically that you're alluding to from April of 2004 to March of 2007 goes from the price change of $255,000 to $575,000 over that time span, and that is the approximate appreciation on a monthly basis that was calculated from that transaction.
So you're not showing the effect of the decline in the market that you just mentioned after the point of 2007 here. Is that fair?
There is no, from my estimation, a decline in the market after 2007. The market has now not appreciated, but there is no decline in any of the data that I saw relative to the properties in question in Ventanas or in Guanacaste.
And this is notwithstanding the worldwide recession in real estate that happened beginning in 2007, as you mentioned in the earlier paragraph. Is that correct?
Correct.
And you're aware that lots of the purchasers in the Guanacaste area are coming from the United States?
Yes.
And in the United States, was there a recession with respect to real estate from 2007, beginning 2007, 2008?
Yes.
And do you think, is your understanding that there was a link between the United States market, real estate market, and the real estate market in Costa Rica, given that the purchasers were the same, more or less?
No one has said that they're the same, more or less, relative to the target audience or the target buyers, target market for these properties. So, no, I'm not in agreement that your correlation between the American market or the North American market or the U.S. market had an effect on the values of these subject properties.
So your testimony is that notwithstanding the fact that there is a recession in the real estate market in the United States, and the United States and the individuals from the United States constitute a substantial portion of the purchasers in the Guanacaste area, it's your testimony that that had no effect on the market of the real estate market in Guanacaste. Is that correct?
Relative to the target audience for these lots, which are in the top 1% or however you 1%ers or 5%ers, they were not affected by the recession in the same order of magnitude that you're alluding to here. So that the subject properties or beachfront lots of this caliber were not affected by the house prices in the U.S.
And what is the basis for that, for your statement?
The interviews that I've had with the numerous brokers, and it's set forth in my report, between Penny Wheeler, whether it's Bob Davey, whether it's, and again, the names are all in my report, so I don't have to repeat them, but it was confirmed with the brokers that this buyer, the class of buyer that was coming in here was not affected by, and it was proven by the data set that they were not affected by this recession.
Let's turn to your sales comparison approach. In your damages calculations, you use a sales comparison approach to value claimant's property. Is that correct?
Yes.
And this is a situation where the value of property is related to the prices of comparable competitive properties. Is that correct?
Yes.
And in section 5.2 of your first report, which is on page 22, in the second full paragraph, you indicate that the reliability of the technique that you're employing depends on, quote, the degree of comparability of the property appraised with each sale, the length of time since the sale, the accuracy of the sales data, and the absence of unusual conditions affecting the sale. Is that correct?
Yes.
So, for example, the closer in time two sale transactions are, the more comparable they are. Is that correct?
That's one factor, but you would not say it's the most comparable, but it's definitely relevant to your analysis.
And you have selected in doing the comparables 3 transactions for each of claimant's properties in order to determine the value of their property as of May 2008. Is that correct?
Relative to the properties that were taken in their entirety, yes. For those properties that were partially taken, there are 6 comparables because there's a before and after, and in each one of those situations, there were 3 sales identified.
Okay, fair enough. And if you turn to page 63 of your report, your first report, and again, this is to make evaluation with respect to the date of May 2008. You are choosing among those 3, it's listed 3 different sales. If we look at the top box, which is the 3 different sales there's a date for the first sale, 06, date for the second sale, 06, and date for the third sale, 2003, correct?
Yes.
But isn't 2003, it's not particularly close in time to 2008, is it?
It is as stated. It's the difference between August 19th of 03 and then May 27th of 08.
Right, so that would be approximately 5 years, is that correct?
Approximate.
And in real estate time, is there a lot of fluctuation in a market that occurs in a period of 5 years?
In this case, you can see that there's a market condition adjustment of 118%. So you would suggest from the data itself that there was a doubling of this property over that time frame.
In determining the value of these properties, you didn't consider the purchase price of the properties, did you? Their purchase price, their most recent purchase price.
In 2 cases where the sales that I can recall at the moment, where the sales were in fact used as comparables, then there was an inclusion. But as it relates to the claimants, no, their purchase prices were not reflected or indicative of the market value.
But wouldn't you agree that one factor you consider in your sales comparison approach is the degree of comparability of property appraised with the sales transaction you're using, correct?
I'm sorry, could you repeat the question?
Sure. One of the factors you consider in your sales comparison approach is the degree of comparability of the property appraised with the sale transaction you're using, correct?
Yes, that's correct.
You would agree, would you not, that you cannot find a more comparable property to compare than comparing the same property at 2 different points in time, correct?
No, I would not agree.
Would you agree that the value of the property, that you're assessing, that its latest price is relevant for determining the valuation of that property?
No, I don't agree.
So when somebody is selling property or buying property, you don't think it's relevant that they look at the latest sales transaction that occurred prior to the property being on sale. So for instance, if I'm buying property that's valued at $100,000, you don't think it's relevant that that property sold 2 years before for $3,000. Is that your testimony?
It depends on the market conditions and the conditions of your acquisition and whether or not that was reflective of a market value at the time.
Fair enough. But what my question is it relevant? Do you think it's relevant, or you would agree that it's relevant, that to consider for that particular property the latest purchase price of that property when you're considering the valuation of that property?
Again, it depends on the exact situation and that you're involved with. So yes, if the acquisition was deemed relevant and reflective of a market value, then one would consider it. If in your analysis it's not deemed to be relevant and not reflective of a market value, then one wouldn't consider it.
But in your view, is it correct that it is worth considering to determine the value or assess the value of that particular property?
Not as a determinant, no.
No, but to take into consideration, I'm not saying that it's an absolute, I'm just saying that something, a factor, you would take into consideration determining the value of that property.
And one would understand it and consider it, but you keep using the word to determine the market. No, you don't use it to determine. You look at it and you make your own assessment, but it's not determinant, no.
Okay, so you would take it into consideration? Do you think that's relevant to take into consideration the latest purchase price or sale price of that property that you're assessing?
Again, if it's within a relevant time frame in the same under same market conditions, then one would consider it. But if it's not and not reflective of a market value that you can use in valuing your subject property, then no, you don't consider it.
And you did not look at the sales contracts for the claimant's properties in determining your value of the properties, is that correct?
But for my analysis of the option agreement for Lot V61, I did not.
Thank you. In section 9.5 of your first report, which is on page 83. You list a number, I'm sorry, I'll wait till you get there. Are you there? You list
Yes.
You list a number of sales comparables, correct?
Yes.
And these are properties that you used as comparable properties for the purposes of valuing claimant's property, correct?
Yes.
And a number of those properties were in Playa Grande and Playa Ventanas areas, is that correct?
Yes.
And in fact, some of those properties are claimant's properties, is that correct?
Yes.
In looking at those properties that you were relying on that are claimant's properties, and I think you answered this question with respect to, for instance, Lot V71, but you also considered in 9.5.4 Lot V59 and in 9.5.5 Lot V61 and in 9.5.8 lots V30, 31, 32, 33, and 34. For all of those, you did not take into consideration the sale and purchase agreements for those properties, is that correct?
I did not see the purchase and sale agreements on those lots, but for, as I testified in 9.5.5, I did see the option agreement where Spence and Wake Up Call had an agreement.
And you would agree, would you not, that sales and purchase contracts contain or can contain useful information about the specific terms of a particular sale?
Yes.
But you nevertheless did not take any of those or look even at the sale purchase agreements in your analysis, is that correct?
They were not provided.
Did you ask for them?
No.
So you didn't think it was relevant, the information that was contained in those contracts?
Based on the verification with Bob Davey, who was the selling agent in most of those cases, he informed me that those contracts wouldn't be available and provided to me enough detail that I was sufficiently satisfied that they were reflective of market value and there were no extraordinary terms and conditions.
You said that they wouldn't be available or valuable? I'm sorry, I'm not sure I understood.
Available, I'm sorry.
Available. Did he give a reason for why?
They were considered confidential.
And did you say with respect to C71, did you see that contract that was you said you understood it was reverted back, but you didn't necessarily, and you knew that there was a condition that hadn't been met. Did you see that contract or no?
I did not.
So once you identified the value, you, based on the three comparables, you then adjusted that value that you calculated just that value. And part of that adjustment, among other things, were physical traits such as beach frontage, topography, et cetera. Is that correct?
Topography and frontage in the one case, whatever I set forth in my report here that I provided earlier to the tribunal and yourselves on slides 11, where the adjustments in physical were for topography, whether the lot had entitlements, or the frontage as you described, or also then in the after condition for the B lots, their undersized nature in the after taking.
Okay, and if, just for sake of simplification, if you could turn to tab 6, which is Navigant's first report, and if you look at page 19, do you have that in front of you?
I do.
And in the table 3, Navigant has identified the percent change on the right-hand column, and that percent change is the percent change, the range, I guess, of change with respect to the adjustments that you applied. Is that how you understand that chart?
Yes.
So according to Navigant's calculations, the percent change ranged from, well, included as much as 121% increase to as much as, actually, if you look at the second chart, it goes all the way down to 74% of decrease from your initial valuation. Is that correct?
I think that's what the chart shows, but I don't agree that it accurately reflects the nature of the adjustments that were undertaken in my report.
Do you have a sense of the high and low range of the percentage adjustments from your report, if you disagree with what Navigant has here in their report?
I know that when I look at the sales in Ventanas and I look for all of the adjustments for the comparable transactions, you will only see minimally adjustments for those comparables for those parcels in Ventanas. And I don't believe that when you look at those charts, which were only adjusted, again, those comparables at negative 12% for most of those, and they're very lightly adjusted, that this chart would then suggest what the magnitude of adjustments were to those comps. The resultant value that you see may have a wide disparity, as I indicated, because of the inefficiencies and the lack of transparency in the market. And the way this is calculated between maximum and minimum, it's showing this wide range and I think distorting the nature or the level of adjustments that were undertaken. What you do see, though, is that the resultant adjusted values do have a wide range, and from that, I made an educated conclusion relative to the ultimate value of the subject property. But the level of adjustments on a per comparable basis throughout the Ventanas lots is not as shown here in this chart.
But I think that, and maybe I misunderstood you, but didn't you say that there was at least, and maybe we're not talking the exact numbers here, but there was a wide range in adjustments, in the amount of adjustments that needed to be made to the properties as a general matter that you had initially valued. Is that correct?
Wide range in the complex properties in SPG and in the B lots. Here you're looking at adjusted value, highs to low, and it doesn't go to the number of adjustments. The number of adjustments is relatively small. All we're doing in this table 3 is showing the disparity between the ultimate adjusted values and the range from which then I had to select the subject property's value after weighting. So that the distortion here is just showing the wide range of disparity in sale prices for the comparables that I had to select from. It doesn't go to the number of adjustments that had to be made to those comparables, especially in the Ventanas lots.
Would you agree that there were a large number of adjustments that you needed to make to the comparables that you had, the value you had reached based on the comparables that you had used?
No. Only the adjustments got large, if you will, for the complex properties in southern, or in the estate lots for SPG and the B lots because of the issues, because of size and everything else. But clearly there was much more uniformity and consistency in Ventanas and in the Guanacaste lots, Playa Grande lots, that were not subject to partial expropriation.
With respect to those that had the disparity and the large number of adjustments or the significant adjustments that were made, doesn't that suggest that the comparable transactions were not particularly comparable, and as a result, the calculation is not particularly accurate?
They were the best comparables that were found in the marketplace. You cannot fabricate data. So to the extent that it was the best data available, that's what was used.
So you would agree, you mentioned that the valuation of the property is, there are lots of different values of property in the Guanacaste region. So you would agree, would you not, that it is a common in that Guanacaste region for various properties, or for a property to have, there to be great differences in valuation of properties in that area? Would you agree with that statement?
No, I don't agree with your statement because you have substituted the word value for prices. There were many different prices because of the transparency and because of the efficiency of that market. But you cannot say that there were many different values. There were many different prices.
Okay, but if there are different prices that can affect the value, isn't that correct?
The collection of prices in a market then you interpret to indicate a value for a property. So that is how the process goes.
Right, so if there are a wide range of prices in the area, then it can affect, it could suggest that there would be a wide range of values for property in that area, correct?
As I've testified to, and as you can see in the data set that we've used, there are wide variations and disparities in the adjusted sales prices for these lots after adjustments, and that is indicative of the market. And from that, one selects the appropriate, or indicates the appropriate value to ascribe to the subject property with professional acumen and judgment. And that's the process. And then what you do is you step back and you say, does that make sense and reasonable in light of all the information that you've analyzed? And that's what we've done in this case.
Would you say, Mr. Hedden, that it's difficult to value properties in the Guanacaste region?
I think it's challenging. I think my report goes to say that. Difficult? No. After 34 years of experience, it was challenging. But I felt that given the information and the interviews and the body of work that I now can show in all of my exhibits, I accepted the professional challenge and feel that I've rendered a credible opinion.
And do you think that given the difficulty or the challenge that you faced, do you think it's fair to say that different people could come up with different conclusions of the valuation for properties in the area. Is that, given how difficult it is, or what a challenge it is to determine the value, is that a fair assumption?
Yes, professional valuers often come up with different opinions of value.
Thank you. Can I have the slide? Can I just have you turn to slide number 10 of your presentation? And here you, in the middle of the box where you have adjustments for physical characteristics, and you list them out, and you list out what effect that had, the adjustments you made. So in the column up above where it says market conditions adjustment, you have a summary there. That's the 10%, 8%, 45%. And then down below, you are breaking that all out, if I'm understanding this correctly, into more detail. And here in particular, you're talking about adjustments for physical characteristics. Is that correct?
Yes.
Did you provide that information?
Yes.
I'm sorry. Okay, sorry. Did you provide that detailed information in your report?
The numbers that you see here were not contained in the report.
And did you not think that was important to include in your report?
That's correct.
Isn't it important for the sake of transparency that people who are evaluating your report to determine the assumptions that you are making have full knowledge of the assumptions that you in fact are making and making when doing your analysis?
Could you repeat that question, please?
I don't know why you ask. Isn't it fair to assume that it's important that you provide, in the interest of transparency, all of the assumptions, all the information, the assumptions that you made in valuing the property?
Not necessarily, no.
You don't think it would be important for somebody to include information, the assumptions you're making here, where you break it down as specifically as you are, in order for somebody to evaluate whether they agree or disagree with the assumptions that you make? You don't think that's important to include that information in your report?
There are no appraisal standards that require one to disclose that type of arithmetic in one's report. And given the knowledge of the tribunal and the venue that we are here, for the sake of simplicity without complexity, I didn't feel it was necessary. And given the fact that I've now presented the rules underneath the model, one can clearly understand the rational way I've approached this problem and explained the situation here.
But Mr. Hedden, notwithstanding your statement, you clearly thought it was important to share with the tribunal at this moment, didn't you? Otherwise, you wouldn't have included it on your slide, would you?
That's correct.
So in fact, you do think it's important for the tribunal and for the parties to understand the underlying assumptions that you made in your report.
Yes.
But you nevertheless did not include it earlier in time than now. Is that correct?
That's correct.
And just to clarify, the line further down on weight, you also, in slide number 10, are breaking it down by weight and how you weighted each of the properties. You did not include that information in any of your reports. Is that correct?
That's correct.
And again, to clarify, but you do think that information is useful and valuable to share with the tribunal and the parties at this time. Is that correct?
Yes.
And to just be clear, on slide 11, where you go into great detail about size and economies of scale and physical characteristics, you also did not include that kind of detail in your report. Is that correct?
Some of that detail was included in my report, but not all of it.
And again, to clarify, you thought that was important to raise with the tribunal and the parties at this time. Is that correct? But not earlier in your report?
I thought it would be beneficial to the tribunal if they attempted to replicate the logic and the math that I had undertaken in this analysis. It was fair to share with them at this time.
But again, you didn't think that it was important to share at an earlier point in time in which people could analyze what you had done and the assumptions you had made. Is that correct?
I think that minimizes the point that I was making. I thought that the ultimate conclusions then are pretty evident and rational, and so that the ultimate conclusion and credibility of the document is not jeopardized by the fact that I didn't show the arithmetic.
I'm sure it's rational and evident to you since you did it, but it may not be evident and rational to those who have not actually conducted that analysis. But nevertheless, I think, Mr. President, perhaps this might be a good time for a break.
If that's consistent with your cross-examination,
Yes,
schedule.
we're at a point where we're going to switch to a different topic.
Then let's do so. Mr. Hedden, may I remind you that you're still under oath, as it were, in the witness seat. We'll break now for 15 minutes. Please don't discuss your testimony with counsel, with anyone, with any of the parties until we resume the cross-examination.
Understood.
Thank you. We'll break now until 25 minutes past.